The highest court in the land has the opportunity to drastically change how careful brokers are in choosing a carrier. The Supreme Court later this year will decide whether to allow state lawsuits against brokers for negligently hiring shady carriers. So, how did we get here? The case we are talking about is Montgomery v. Caribe Transport 2, also known as Montgomery v. C.H. Robinson. I spoke with Matt Ray, a trial attorney for Armstrong Teasdale who had represented C.H. Robinson in the lawsuit. The legal battle started with a truck collision in 2017.
So this was a case where C.H. Robinson was asked by one of its customers to arrange for the transportation of some freight from Ohio down to Arkansas and also to Texas. And in the process of doing that, it contracted with an independent contractor, a motor carrier. The motor carrier went to Ohio to pick up the goods, loaded them onto their truck, and were driving to Arkansas and Texas.
For that route, the independent carrier, Caribe Transport 2 LLC, had its driver, Yosniel Varela Mohena, haul plastic pots through southern Illinois in a 95 Freightliner, where he got into an accident. Court documents state that Varela Mohena veered off the road into a different tractor-trailer that had stopped on the side of the road, a 2015 Mack truck. That stopped truck's driver, Sean Montgomery, was just outside the truck. Varela Mohena's Freightliner struck the back of the stationary Mack, injuring Montgomery. Montgomery and his legal team sued the parties involved in the crash for his injuries. They sued the driver that crashed into Montgomery's truck, sued the carrier that employed him, Caribe Transport, and sued Robinson for using that carrier. Suing the driver and the carrier sounds pretty straightforward. Suing C.H. Robinson, however, required a disputable argument that Robinson had negligently hired Caribe and its driver, making the broker somewhat liable for the wrongs committed. Montgomery's party argued that C.H. Robinson should have known that Caribe had a history of safety problems and was not fit for the job, including hours of service violations, a high percentage of out-of-service designations, and an overall conditional safety rating. C.H. Robinson's team asked the courts to dismiss some of the claims.
Anytime you're asking a court to provide relief, you're usually presenting something to that court in the form of a motion. So what we did on behalf of C.H. Robinson was file a motion and essentially ask the court to dismiss the claim for negligent hiring. And what we did at the time was we cited a federal law known as the FAA, which is an acronym for the Federal Aviation Administration Authorization Act.
The FAA, or FAA, goes all the way back to deregulation. The law declared that some states' transportation regulations are a burden to interstate commerce and should be preempted. Even though the bill's name is only about aviation, it also dealt with motor carriers. The rule effectively blocks states' authorities to influence the price, route, or service of transporting property. But it makes a specific exemption for the safety regulatory authority of a state with respect to motor vehicles. Whether or not a broker could be found responsible for negligent hiring in this case would fall on Illinois, which means that the FAA might prevent a state court from allowing Montgomery to seek damages from a broker like C.H. Robinson.
What we were saying to the trial court was this federal law precludes Mr. Montgomery from suing C.H. Robinson for negligent hiring. And we're asking you, judge, we're asking you and your court to essentially dismiss that claim because of that preemption.
The judge at the trial court ruled in favor of C.H. Robinson. Montgomery's party appealed to the Seventh Circuit Court of Appeals, which also ruled in favor of C.H. Robinson, and then Montgomery's party appealed to the Supreme Court.
C.H. Robinson was also interested in having the Supreme Court take the case. I'll get to that in a minute. And so it supported that request to go to the Supreme Court. And the Supreme Court, which only takes usually about 75 to 80 cases a year, decided to take that case and to hear this issue about whether the FAA preempts that state common law cause of action that Mr. Montgomery filed. The way that the law exists in some parts of the country is inconsistent with the way that it exists in other parts of the country. So in some areas, courts have said, yes, the FAA preempts a negligent hiring claim. But in other courts, in other parts of the country, courts have said, no, that preemption doesn't apply. So you could be in one state and those kinds of claims could be preempted, and you can drive into a neighboring one and they could not be. So the goal of getting to the Supreme Court is to try to have the court address this and bring some clarity so that there's not a patchwork of law that exists around the nation.
So how could the Supreme Court impact freight brokers in this case? It seems that there are three main paths a Supreme Court ruling might take.
One is that the Supreme Court could affirm the Seventh Circuit and the trial court. In other words, it could say, you made the right ruling, and you correctly ruled that this FAA preempts claims for negligent hiring. It could be that the Supreme Court goes even further than that and says that the federal law preempts all of those kinds of claims, whether it's negligent hiring or a claim for vicarious liability against brokers like C.H. Robinson.
That last ruling, that there is no preemption, could open up brokers to more risk. It could have a significant impact on for-hire trucking to the benefit of larger carriers and the detriment of smaller carriers.
And I'll speculate a little bit here, but I think that if the court decides that there is no preemption, and these are the kinds of claims that injured parties can bring against property freight brokers, that you'll see property freight brokers are likely to steer their work more towards larger motor carriers with larger fleets, and that smaller carriers with smaller fleets may be left out to some degree.
Economies of scale allow larger carriers better resources to communicate safety-sensitive statistics and also to build a stronger safety track record, which risk-averse brokers might gravitate towards. With the freight recession and spiking diesel prices, smaller fleets are already hurting as it is. If the Supreme Court decides that there is no preemption to protect brokers, it could contribute to more consolidation among for-hire carriers. The court has already heard arguments from the parties in this case in March and will be issuing their decision sometime later this year.
That written opinion will probably come out sometime in April, May, or June. So I'd expect it to be before the 4th of July holiday. And each of the justices seemed to take a different approach to the issue that was before them. And I'll just give you a couple of examples. Justice Kavanaugh seemed to be focusing on the day-to-day impact of the current patchwork of liability as it relates to claims against property freight brokers.
What do you do with the fact that the brokers, I think the amicus brief of the Transportation Intermediaries Association, particularly pages 20 to 24, really go in detail of if tort liability extends to them, how are they going to assess and evaluate the safety of drivers in a particular trucking company? How are they going to figure out do they have an alcohol drug issue? How are they going to figure out English proficiency, which of course is a critical issue at the current moment that's being discussed? How are they going to do this is the real concern that's raised in that brief and by respondents that I think, is something you need to respond to.
A different example would be Justice Thomas. Justice Thomas asked about the historic regulation of the trucking and the freight broker industry, asking questions about the ICC, which is an entity that existed as part of the federal government in connection with and before the Federal Motor Carrier Safety Administration.
Interpretation of the safety.
With respect to the use or the role of brokers, how significantly has that increased?
I agree with what Mr. Boutros said. It has increased markedly. Before the deregulation, there were only several hundred brokers, is my understanding. Today, there are approximately 25,000 federally registered brokers operating, from small sizes to as large as C.H. Robinson.
What role did the ICC play in regulating transportation in intrastate before deregulation?
I don't know exactly the extent of the role. My understanding is that
So each of the justices really kind of took a different approach and looked at this through a different lens. And it wasn't entirely clear to a lot of us what the outcome of the case might be, at least based on the questions that were asked.
And it sounds like we'll get an answer sometime in the next few months, at least before the end of July.
Yeah, I think so. We'll know the answer soon.
All right, Matt, thank you so much for talking with us today.
Thank you for the opportunity. I appreciate it.